When can parents opt their children out of the curriculum based on their religious beliefs? Do parents have a First Amendment right to opt out of an LGBTQ inclusive curriculum? What does the Supreme Court's recent decision in Mahmoud versus Taylor mean for schools?
Oh man, well, I think it could mean an awful lot. This was
Or nothing. Who knows?
Or nothing. Yes, it could be one or the other. Who knows?
It's probably somewhere in between.
Thanks a lot, Supreme Court. This was a big decision that came out on the last day of the term, along with a bunch of other decisions, many of which were also big. The Supreme Court is definitely making some big waves all over right now. But today, we're going to dig into the ripple effects of the Mahmoud versus Taylor decision today on Chalk and Gavel. So welcome to the show, everybody, where we explore how the law shapes education one case at a time. I'm Jamie Cudlitz, a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
The kids are alright. The kids are alright. The kids are alright.
All right, welcome back, everyone. Please take a moment, if you would, to like, rate, review Chalk and Gavel. It's a huge help for us as we continue to grow the show and helps us get discovered by those all-powerful algorithms. If you're watching this on YouTube, please subscribe to our channel, give the videos a thumbs up, all of that fun stuff. You can find a lot more information about Chalk and Gavel at chalkandgavel.com, including our teaching guide if you want to assign this in your classes or for professional development, whatever it might be, or if you're just looking for an episode on a topic that you find interesting. You can also find us on social media at Chalk and Gavel, or you can go to our Patreon page, patreon.com/chalkandgavel, and pledge some support. $2 a month. It goes a very, very long way in helping Jamie and I continue to do this show and bringing you fascinating content like this, where the Supreme Court throws a wrench in it.
Yeah.
Speaking of the Supreme Court throwing a wrench in it, Jamie, what's our bell ringer for today?
Yeah, so today's bell ringer is the AJT versus Osseo area schools Supreme Court decision that came out around mid-June. So this was a unanimous decision, which is always very interesting when the Supreme Court throws down a unanimous decision.
Right. Yeah.
Yeah. So this was the case about whether or not students with disabilities need to meet, a higher standard of negligence or bad faith or whatever when it comes to suing schools under the ADA, the Americans with Disabilities Act, and Section 504. So basically, the ruling here was no, students do not need to meet a heightened standard here that's like, the school acted in bad faith, or there was like gross negligence or severe misjudgment or whatever. They don't need to meet that high standard if they are going to sue and say that they were discriminated against under the ADA or Section 5.
Nice. Okay, so I guess that's not a wrench then. That sounds like a point of clarity.
It does sound like a point of clarity. So basically, the implications here, there could be more lawsuits. It could force schools and school districts to get a little bit more, what's the word I'm looking for?
Serious?
Yeah, they could get a little bit more serious about their procedures and their sort of anti-discrimination kinds of
Never a bad
policies,
thing.
Right? Not a bad thing. No.
Yeah.
So
Nice.
So that's today's bell ringer. So that's
okay.
I guess you could say that would be a win for students with disabilities.
It sounds like it. Yeah. And my understanding of the case is it didn't lower the standard for when you can bring a disability claim. It just didn't recognize this heightened standard that some circuits had started to apply for this very specific kind of discrimination claim. So like the general rule is still the rule that's applicable to other discrimination claims under these laws. So just, it's kind of an affirmation of the status quo, I guess.
Yeah.
Nice.
Yeah, exactly.
Which, hey, 9-0. I'll take it.
9-0. That's a good one.
Though speaking of 9-0,
This case that we're going to talk
Yeah.
about today was not.
no, it wasn't.
No, this case. So let's go ahead and get right into it because we got lots to talk about. So this is Mahmoud versus Taylor. It's a big case. It's another entry in the growing parental rights movement in education. For the first time, the Supreme Court has now grappled with whether or not parents have a religious liberty right to opt their students out of aspects of the school curriculum. And the answer, ladies and gentlemen, is yes, at least according to the 6-judge conservative majority. The answer is yes. Parents now have a religious liberty right to opt their students out of aspects of the school curriculum that may, in their minds, the parents' minds, be a burden on their ability to raise their kids according to their faith.
Right.
And
Yeah.
now you've heard us talk lots about this.
We've talked about Mahmoud once or twice, haven't we?
This is now at least the third time. This is the third episode that we've had on Mahmoud. So we had one about the lower court appellate decision that came out.
I think it was the trial court.
Was it the trial court that we did?
Yeah. Yep.
Okay.
And we did a bell ringer on the appellate decision affirming the trial court.
Yes. Okay. That's right. So
We've
I
been
guess
on this one since the beginning.
That's right. So yeah. So we did the trial court. We did the appellate court decision for a bell ringer. We covered with Richard Katskee. We covered the oral arguments. I was actually there in person for those oral arguments, which was fascinating. And now today, ladies and gentlemen, we are going to talk about the decision that the 6-justice conservative majority handed down in Mahmoud. Okay. So is this monumental? Is this a nothing burger? I think all of that remains to be seen. But
I'm leaning more towards the former. But
I agree. And we're going to talk about why. I will give you a little spoiler alert. I have sort of heightened radar as a former school administrator here about the implications of opt-out policies, which didn't seem to get as much attention in the oral arguments
Right.
or in the opinion.
or in this decision, yeah.
Yeah, exactly. Which is a little concerning to me because I think if this had been much more of a focus, the fact that what schools are responsible for doing when somebody opts out of a curriculum, how much work that becomes, that creates
Potentially.
for a school.
Depends on how you do it. Right.
Exactly.
But yeah, those practical concerns are
pretty
I won't say
significant.
absent, but and they're not absent from the decision, but they're not up front and center.
No,
So
they're not.
you'll bring the practical concerns. I've got some legal concerns as well. So
Well, let's talk about those things. Yeah. So, all right. So we're going to just really quickly recap the facts of this case as they appear in this particular opinion, because it is right, Chris? It's very interesting to see what the conservative majority, the opinion here in this case was written by Alito. It's very interesting to see what facts were highlighted and what facts were kind of dismissed or low-lighted, I guess you could say.
Yeah, right.
So
it's a different story, right? And that's something that's really fascinating since we've covered this case so often, is just to kind of see how the story has evolved, even though there aren't new facts, right? And to see what points of emphasis there are. So yeah, it is interesting to see what Justice Alito and the majority opinion emphasizes, because I think that is going to tip his hand a little bit.
Yeah. So as we mentioned, this was split down party lines, 6 conservative justices on one side, 3 liberal justices on the other side in dissent, and Alito wrote the opinion. There was a concurrence by Thomas, but he was just doing his own thing.
As he usually does.
Yeah. So here are the facts. So according to the opinion, in 2022, the Montgomery County Public Schools Board of Education, that's in Maryland, determined that the books that were being used in the existing English language arts curriculum were not very representative of the many students and families that lived in that community because they didn't include LGBTQ characters. Okay. So then they went through this book review process to look at other books and to see if they can increase representation in the curriculum, representation specifically for LGBTQ individuals. And according to the court, though, one of the criteria for reviewing the books was whether the books reinforced or disrupted ideas of heteronormativity, cisnormativity, and existing power hierarchies. Just
interesting.
Yeah, it's very, very interesting. It's very interesting. I'm going to pause for 2 seconds to just let let you know I'm not in my normal studio environment. I help run a summer camp in the summer.
You don't have that much wood paneling in your normal studio?
No, everything here this place could go up really fast in a fire. Everything is wood. But yeah, there's lots of children playing outside. There's nothing I can do about it. So we've got a little ambiance.
Right. It's perfect.
Yeah, okay. Thank you.
Yeah. It wouldn't be Chalk and Gavel without the sound of kiddos running around.
Yeah, exactly. They're having fun. They're out on the lake out there. We're up in Canada. It's a beautiful day here. Anyway, so sorry for that little side note, but I wanted to let you know why there's probably a lot of screaming and, laughing and all that stuff in the background. So again, the court here said that the review process wanted to look at whether or not books reinforced or disrupted these ideas of heteronormativity, cisnormativity, and existing power hierarchies.
Right.
So that's interesting.
And that, the lower court opinion talks about the process, but it didn't talk about, I don't remember, specifically the criteria of challenging heteronormativity or challenging this idea that, everybody is straight.
Yes.
Or that to be straight is to be normal, right?
Yes. Yes.
And, that I guess maybe there's a slight difference between increasing representation and disrupting these ideas. Maybe there's some daylight there. And I think highlighting the disrupting ideas of heteronormativity really starts to get at this idea that Alito really picks up on with this curriculum, which is that it is normative in nature.
Yes.
So, again, that's an emphasis point where we kind of see where this is going.
Exactly. So to keep going with the facts here, based on those criteria, the board ended up selecting 13 LGBTQ plus inclusive texts for use in the ELA curriculum from pre-K through 12th grade. 5 of those texts were approved for kindergarten through 5th grade, elementary school. Okay. So interestingly, the opinion actually spends a decent amount of time summarizing all 5 of these challenged books. They take up
the content of the books takes up way too much of this opinion.
Yeah, I think all told, the description and the analysis of the books with pictures and all that stuff takes up a good 15 out of 50 pages of this opinion. So this is the Supreme Court. It's the Supreme Court Book Club. They're
the Supreme Book Club of the United States.
Exactly. There is a lot of discussion about the content of these books.
Right.
So anyway.
Yeah, there's images of the books too in an appendix.
Yes.
Justice Alito put pictures of the books in the Supreme Court's decision. So the content of these books is really, really important to the ultimate decision, I think.
Absolutely. So anyway, what happened was the board suggested that the teachers incorporate these books into the curriculum the same way that they would incorporate other books that are not sort of mandatory, you must read out of this. So what that kind of means is, go ahead and put them on your bookshelves. Students can find them. They can read them on their own. They can maybe check them out of your classroom or whatever. You could recommend them to students. You could offer them as options for literature circles, book clubs, read alouds, whatever. So it's not like we're going to mandate that every teacher teach out of these books, but they are approved by the board for your use as a teacher. Okay. And there is also professional development, workshops, and guidance documents for teachers to help them navigate potential discussions that these books would potentially create. But interestingly, here again, in this opinion, it highlights the guidance that, quote, encourages teachers to disrupt the either or thinking of their students, unquote, when it comes to issues of sex and gender. So this is kind of very interesting to me. And we saw this play out in the oral arguments of this case. There is a spectrum, at least the courts have repeatedly navigated this spectrum over the last, 50, 100 years of what it means on one side to expose students to ideas, okay, whether they agree or disagree with them. We're talking about exposure. Is it okay to expose students to new ideas, things that they don't know, right? The other end of the spectrum is coercion, right? Are we exposing or are we forcing people to think a certain way? And the courts have basically said, in many cases, it's perfectly fine to expose them to ideas. You don't have to agree with them, but you can't be restricted from exposing kids to ideas. That's okay, according to the courts. The other end of the spectrum is
before Mahmoud.
Before
This
Mahmoud.
is all before Mahmoud,
Yeah,
right?
everything is before Mahmoud.
Yeah.
And the other end of the spectrum is if you try to tell people what to think, the courts have had a problem with that. And so
Right.
it's very interesting that the opinion here, it highlights some of the language from the guidance that says, it encourages teachers to disrupt the either
Right.
or thinking of their students when it comes to issues of sex and or gender. Now, I think depending on who you are, you can look at the phrase encourages teachers to disrupt as either coercion or exposure.
Right. You're exposing them to alternatives, but this is all getting highlighted in a very specific way to kind of show how the teaching guidance was in many ways intended to promote a particular view about gender and sex.
Exactly.
And so, I think that like the reason this all gets highlighted is to emphasize the ways in which like this wasn't a neutral curriculum, maybe.
Yeah.
And, Jamie, to your point, like, the historic line, at least until Mahmoud, has been between exposure and coercion. But, that's no longer the rule. Or is it? We'll get to that in a second.
Yeah, it is and it isn't. And it's largely because this case is sort of in a novel way approaches this question from a religious liberty standpoint, right? And that's what kind of makes things a little funkier.
Right, because a lot of those
case.
claims have been First Amendment rights to receive information claims by students and things like that. So like,
exactly.
Because this is about a parental right to direct the religious upbringing of children, like it's a whole new ballgame.
Right. And as we know, this particular court has had many things to say about religious rights. So
about the free exercise clause? Really?
Yeah. Yeah.
Oh, that's funny.
It is.
It's almost like we almost had a religious charter school at this session.
That almost happened.
That did almost happen. That like a 4-4, like it got as close as it can get.
That's right. So just to wrap up the facts here, at least according to the opinion. So they put out these books. They allowed opt-outs initially. The board allowed opt-outs initially, but according to the board, that got a little too cumbersome. That was a little too complicated, I guess, over time. And they reversed the decision overnight, one night in a board meeting. And they just came out the next day and said, you know what? We're no longer offering opt-outs for this because it's not a part of the sex ed curriculum. This is, the ELA curriculum. So we don't have to offer opt-outs. And so you're done. And then a group of parents.
I remember making a lot of, when we covered this at the trial court, you and I kind of faulted the school board for like their lack of communication and like the flip-flopping that they did. Yeah. And none of that is a part of the story from the Supreme Court, which I actually kind of find interesting. Like, and it might be that they're just not getting bogged down in the administrative aspects of all of this. But, I found that the absence of that was interesting.
Yeah, it is. It is. Because I think, I think that schools often do and are told to do essentially by law to make their processes transparent and to get parental involvement and all of that stuff. And if we have a situation here where that process might have been compromised in one way or another, or it wasn't handled as well as it could have been, and they did talk about it in the oral arguments. There were comments made about board members making specific statements that might have
been anti-religious or
exactly. And so, it's if you haven't listened to the other episodes that we've done on this case, we kind of get much more into the weeds on those topics in those episodes. So, if this is interesting to you, like it is to us, go check out those other episodes. This is just a really fascinating case. So the end result here was that a group of religious parents, they were from a variety of different faiths. They filed a lawsuit basically saying that not providing opt-outs basically burdens their right to direct the religious upbringing of their children. The trial court, as we said in episode 12, the trial court sided with the school. The appellate court affirmed that decision, so also sided with the school there. And then the parents appealed to the Supreme Court. The Supreme Court granted cert in January. They heard the arguments in April, and we've got a decision at the end of June, the end of the term. And so, Chris, let's dig into it.
Because there's a lot to unpack here. This is not one of those decisions that gives us bright lines.
Yes.
This is a ambiguous, squishy, shifting sand kind of opinion where there's not a lot of firm ground to really kind of unpack exactly how far this decision is going to go, what it means, or even how schools can apply this. I'm so worried about what schools are going to do with this decision because it's so ambiguous.
Yes, exactly.
Which is, what we're going to do. We're going to unpack it. We're going to make sense of it.
Yes, we're going to take as much of the ambiguity away as possible, but they didn't give us a whole lot to work with here.
Yeah. No, I'm putting on my my textual analysis hat pretty hard. Okay, we got to read between the lines.
Let's do it.
Let's do it. So, as Jamie said, this was a 6-3 decision. Justice Alito wrote for the majority. Justice Thomas, no relation, he did join the majority in full, but he also had his concurring opinion, though, as Jamie said, he's just writing for himself, and it's kind of doing the classic Justice Thomas thing where he's kind of signaling like, hey, I want to rethink this entire body of law about free exercise rights and how that relates to schools. He really kind of emphasized the historical aspects of the curriculum and whether or not history was on the school side for not allowing opt-outs from a curriculum that taught about gender and sexuality, which to me felt a little left field, but I'm not Justice Thomas. And then
you're Dr. Thomas, but not Justice Thomas.
Yeah, I'm not Justice Thomas yet. And then the dissent was written by Justice Sotomayor, joined by the other two liberal justices, Justices Kagan and Jackson. And, I'm not going to spend a ton of time on the dissent because just assume that if I'm talking about the majority opinion's perspective, the dissent disagreed.
That's
pretty much what it is.
It's about as simple as it gets, man.
Right. So the majority opinion starts with the free exercise clause. It's a fantastic place to start. Let's start with the text of the free exercise clause of the First Amendment to the United States Constitution. It says, Congress shall make no law prohibiting the free exercise of religion.
Okay, no argument there.
All right, yeah, cool. What do we do with that, right? Like, this is always one of those fun things about constitutional interpretation. Like, how do you get from that language to the language about, like, what we'll talk about in a second, like substantial interference and substantial burden and all these other... That's just constitutional analysis. That's neither here nor there, but... All right, that's what the Constitution says. So based on that language and based on prior court cases, the majority opinion emphasizes the rights of parents to direct the religious upbringing of their children and the importance of that right within our constitutional order. This goes back to early 1900s cases with Pierce versus Society of Sisters, Meyer versus Nebraska. Like, part of liberty in the United States is the right of parents to direct the upbringing of their children. We haven't had a lot of clarity from the Supreme Court about exactly how far that right goes, but now we've got Mahmoud versus Taylor.
Yeah. Yep.
So, so far I'm on board, but here's where things start to go off the rails for me personally with Justice Alito's opinion. So then we get a standard. We get a standard for how do we determine when those rights to direct the care and upbringing of your children are violated. And this is the key to the case because this is the line, right? Like, this is the line where if you're on one side of the line, according to this decision, you're likely to get an opt-out from school curriculum. But if you're on the other side of the line, then the school doesn't have the obligation to provide you an opt-out, and there's no free exercise, there's no burden on the family's religion based on the curriculum. So here's what the court says. The court says that we have held that parental rights to direct the religious upbringing of children are violated when governmental policies substantially interfere with the religious development of children.
Okay, well, that sounds very subjective.
Really?
Yeah.
But it's a substantial interference.
Yeah, but how substantial? Who determines what's substantial and what is interference? And, but again, surprise, surprise, there's subjective language in these court
all
opinions.
Language is subjective, Jamie.
No, I get it. But some is more objective than others. Right?
Substantial interference is not a self-defining term, but that's the standard, right? Like, that seems to be the standard.
Okay.
What does that mean? You're exactly right that it's not self-evident, right?
Yeah.
So the court goes on to say that a government burdens, and this is a direct quote from the opinion, a government burdens the religious exercise of parents when it requires them to submit their children to instruction. So submitting to instruction, being required to send your kiddo to public school.
Yep.
That poses, quote, a very real threat of undermining the religious beliefs and practices that the parents wish to instill.
Oh,
so we've got this tension, right? Like between what the school is teaching and the religious beliefs in the parents, and the standard now is like, it's a substantial interference when there's a real threat of undermining. So it doesn't have to like contradict, it doesn't have to compel belief, it just has to undermine. Right.
Yeah.
So like,
which makes it even more subjective than compel belief, or, like,
right.
It adds more ambiguity.
Right. Yeah. It does not lend itself to clarity.
No.
So, to kind of help us make sense of this, the court then looks to prior case law, like it always does.
Yep.
To kind of support this idea and to like defend this standard, because this standard is, they ground it in this prior case law, but it's novel, it's new. And so, they set up this tension between parental rights and school authority, and to kind of show how those rights can be burdened by school and how they've dealt with that in the past. So there's 3 cases. First is Pierce versus Society of Sisters, which is from 1925. And this is the case where basically the court said that the state, I think it was Oregon, can't force students to attend public schools only. According to the court, Pierce is, it stands for the proposition that the parental right to direct the care and upbringing of your children protects their decision to send children to private religious schools instead of public schools. So basically, there is a right to opt out from the entire school system. Like you can't force a kid to go to public school. So that's
and that
Pierce
was
versus Society of Sisters.
100 years ago this year.
Look at that.
Yeah.
Happy anniversary. And the next one is West Virginia v. Barnett.
Oh,
this
that
is the
was
flag salute case.
Yeah, the flag salute case from the 40s. Yeah.
Yep, 1943.
Yeah.
One of my all-time favorite decisions because I think it's really, really well written and a really, really important one.
This was the Jehovah's Witnesses being compelled to salute the flag and pledge allegiance to the flag. And the decision was, schools, you can't force somebody to do that. And listen, anybody who's a teacher probably... I wouldn't say everywhere, but my guess is, in most schools, it's pretty well known that you can't force somebody to say the pledge.
Yeah. As one of my law professors once joked, no school is above the law, but there are schools the law hasn't caught up to yet.
Yeah, exactly. I love that. That's great.
I wish more people knew that you can't force students to say the pledge because it seems to be something that...
And that was 1943 in West Virginia versus Barnett.
Right.
That falls into the coercion side, the compelling speech, right?
Yeah, and that's what the court said. They said that was in what the court called an especially egregious kind of direct coercion. It was a requirement that students take a direct affirmation contrary to their religious beliefs or contrary to their parents' religious beliefs.
Right.
And, interestingly, Barnett was decided as a free speech case, not as a free exercise case.
Yeah, that's
or an Establishment Clause case. So, it's interesting that Alito's using it, but, I think it does lend itself to this idea that schools can't compel beliefs.
Exactly.
No officer, high or petty, shall prescribe what shall be orthodox in opinion or other matters of belief. That's what Barnett says.
Okay, so these first 2 cases that you mentioned, it all makes perfect sense to me.
It does.
Until we get to the third.
Into Yoder. Right. Yeah, it's like me, Jamie.
I'm sorry.
So
we've talked about this a lot, folks, offline.
We've had to make sense of this. It's been a process.
Exactly.
So Wisconsin versus Yoder is a 1972 case in which a Amish community in Wisconsin decided that they didn't want to send their kids to school after 8th grade. And Wisconsin had a law that said children have to go to school until they're 16. 8th grade is around 14. So there was a year and a half or 2 years where these Amish families weren't sending their kids to public schools, and they got in trouble for that. They got, the truancy laws or the attendance laws.
Yeah.
They got fined. And so these Amish families brought this lawsuit arguing that being compelled to send their kids to public schools violated their religious rights to direct the care and upbringing their children, because their argument was essentially that public high schools in the United States were so antithetical to the Amish faith that sending their kids to these schools would completely undermine their ability to integrate them into the Amish community.
Yeah. And we got to keep something in mind here. We're talking about the law was requiring them. They weren't saying we don't want to send our kids to school at all. They were just saying, past 8th grade, there's something that goes on in our faith that requires, our kids at this particular age to do X, Y, or Z or whatever. Mm-hmm. And this was like you said, a 1.5 to 2 year kind of obligation.
Right. And the court basically weighed those two things. Like, is that 2 years worth the infringement on this family's religion? And for the court, they basically said that like forcing these kids to go to high school would impose a serious barrier to the integration of these kiddos into the Amish faith and community. And so like, it was pretty much a like either or choice here for this Amish family, like 2 more years of school or like risk not having your children integrated into your faith. Yeah. And so like the court looked at that and said like, no, Wisconsin, you can't do that. You can't force them to basically give up their faith through the threat of, requiring them to go to public school.
And so this is the case that Alito really hangs his hat on, right?
It's cited like over 40 times in the opinion.
Wow, really?
Yes. And here is my big challenge with it. I think Alito misrepresents Yoder.
Well,
it's never happened before. Everyone always interprets cases the way I would. But like, that's one of these things. Like that's the fight, right? Like so much of the fight is like trying to not twist. That's not the right word, but to interpret these cases to, support your views. Yeah. And, to me, like, I think Alito, what he does here is he basically substitutes parts for the whole. So let me give you an example. Yeah. So in the introduction of the Mahmoud opinion, Justice Alito writes that, that phrase, a government burdens the religious exercise of parents when it requires them to submit their children to instruction that poses a very real threat of undermining the religious beliefs and practices that parents wish to instill. Okay. So that's from the introduction. That's kind of the rule of Mahmoud.
Right.
So, that language is quoted directly from Yoder. Very real threat of undermining. That's a direct quote from Yoder. Yeah. But what Justice Alito does is he changes the second part of that phrase. In Justice Alito's version, it says a very real threat of undermining the religious beliefs and practices. What the court actually said is compulsory school attendance to age 16 for Amish children carries with it a very real threat of undermining the Amish community and religious practices as they exist today. So essentially what he does is like the threat in Yoder was like a complete denial of religion. And what he says is, oh, well, it wasn't that. It was a complete denial or disaffirmation or undermining of specific beliefs and practices. So it's no longer the whole, it's now a part.
Yeah. And so, yeah, exactly. So I guess another way to say it is you look at Yoder and you're saying like they were fighting against this almost like this 2-year obligation that pulls kids completely away from the community, essentially, which is such a huge part of the faith. It's like it undermines the entire process. And so at least the way I'm kind of interpreting these sides is like you've got a really, really big thing happening here with Yoder. And you've got, and I'm just sort of overemphasizing. It's a
holistic thing.
The extremes
a
here.
Specific belief.
Yeah. Like, you read a book, right? Like you're exposed
one time
to one idea in one book in whatever. And it feels like he's equating the two.
Exactly. Yeah.
And I think, listen, I understand, everybody's coming at this from different places. And I think that there are some people who probably feel that those two things are the same. There's pretty much 6 justices.
I was going to say there's at least 6 justices who do. Right. And that's kind of the language that Alito uses. He doesn't talk about like the extent of the infringement. Instead, he talks about like of the same character as the burden in Yoder. Okay. So like for Alito, Mahmoud is of the same character as Yoder.
Yeah. Yeah. Yeah.
And so that's kind of where the standard comes from. And, I think, I don't think that's the best reading of Yoder, but as we joked about already, I'm not on the Supreme Court.
That's right.
So that's what we have to go with. And, based on those 3 cases and, focusing on this idea of substantial interference, the court then kind of gives us things to think about when we're thinking about whether or not there's a substantial interference with the right of parents to direct the religious upbringing of their children. Yeah. So this, I think, is probably one of the most important passages of the entire opinion because it gives us the factors that courts are going to look at, or that they need to look at in order to determine if there's a substantial interference.
Yes.
And
yes.
this isn't a criteria test. It is very much a factor thing where we got to look at all this stuff and kind of put it into the trash can, shake it up, and see what comes out.
Exactly.
And that is not always the easiest kind of standard to apply. So here's what the court says. The court says that this analysis will always be fact intensive. So at the very top, it's going to depend on context.
Yeah, which means there's going to have to be a lot of conversations. There's going to have to be a lot of discussion. There's going to have to be a lot of gathering of facts, right? Like, you know, if somebody requests an opt-out, you can no longer say no. And they're also not, well, I don't think anybody's going to have a problem, at least on this majority, if you just blanket said yes. But what they're saying is, you know, in order for you to make a decision, you've got to get the facts. You've got to do some digging. You've got to do some work.
Yeah. Yeah. And saying yes is probably not going to violate anyone's rights,
right?
Except for maybe the child's rights, because that is something that is completely absent from this whole discussion, is what rights the child has independent of the family. But
I'm sure there'll be a case about that at some point.
Well, we'll see. Because that was a big thing in Yoder too, is like, where are the kids in all of this stuff? Like, do the kids want to go to high school, or they want to go be, you know, to the Amish community? But I digress. It's very fact intensive, right? This analysis. So here's what it's going to depend on. It will depend on, and this is a direct quote, it will depend on the specific religious beliefs and practices asserted, as well as the specific nature of the educational requirement or curricular feature at issue. Okay, so religious beliefs, that's part of it.
And the curriculum.
And the nature of the curricular requirement or curricular feature at issue. So like, I don't know if that means like, if it's a one-off thing, we're going to treat it one way, or if it's like a core state curricular requirement that I have to teach you about, we're going to treat it a different way.
Yeah.
I'm not really clear on what that means.
No.
We got to think about it. So it's something we got to think about.
Okay.
And then other ones, it goes on to say that educational requirements targeted towards very young children, for example, may be analyzed differently from educational requirements for high school students. So there's something about age here. Yeah.
So this is I remember something from the oral arguments when they were talking about, you know, evolution, for like, is this going to apply to the high school courses on evolution or whatever? So I think what the court is potentially doing here is saying you can take that under consideration. Right.
Right.
So you might, you know, I guess what they're trying to say here is like, listen, the issue at hand here is a bunch of LGBTQ inclusive books at the elementary level, which could potentially be different than evolution at the high school level, or, you know, something.
Younger students are more impressionable.
Yeah.
There's a greater deference to adult authority. Like, there's very specific things about elementary school students that just make them more susceptible to kind of the coercive or the implicit coercive power of the classroom. Right. And Alito is very sensitive to that here. Yeah. And, you know, I agree with that.
Yeah. Totally.
So the other things we got to think about, it goes on to say that, quote, a court must also consider the specific context in which the instruction or materials at issue are presented. Are they presented in a neutral manner, or are they presented in a manner that is hostile to religious viewpoints and designed to impose upon students a pressure to conform?
Okay, so here's where he's pushing that coercion line of thinking, right?
Right. Well, don't use the word coercion, because that's not the standard. And
no, it's not.
Very clear that that's not the standard. This is one of those situations where the court just like I don't like that word. I'm going to use this word.
Change
but it's the same idea.
But like the other piece of it, though, is the hostile to religious viewpoints, right?
I think the most important word in all that is neutral, right?
Yeah.
Like, are you treating this as one idea amongst many, or are you treating this as the right way to think?
Yeah,
and that I think is the key.
Yeah, or any other ideas are lesser, or
or wrong,
or whatever, right? Yeah.
And so, like, you know, Justice Alito really hangs his hat on this idea that these LGBTQ inclusive books are normative. They're teaching a moral message. And then he says that, like, the teaching of these books was done in such a way because of this teaching guide as to affirm those beliefs, or to, like, basically say that, you know, that was the right way of thinking it, and other ways of thinking it are wrong or lesser. And, you know, that's I think, like, that's the thing that drives this decision. Is it is a non-neutral curriculum taught in a way where the teacher is putting their finger on the scale of belief.
Yes. And this is, like, I think it's important here to talk a little bit about implications, because a lot of times when stuff like this happens at at the court, at the Supreme Court level or whatever, that kind of, I don't want to say upends precedent, but adds another layer of complexity to the situation and ambiguity to the situation. A lot of times what schools do is they just take the path of least resistance. And I understand why, because this is hard and everything. And they just decide, you know what, we're not going to take any chances. We're just going to water everything down as much as possible so that we can avoid a lawsuit. But what also is happening here is, like we said before, this is squishy. There's not a lot of helpful definition here, which means that if you are willing to put in the hard work to determine, can we work these ideas into the curriculum in a neutral way, in a very neutral way, without putting our fingers on the scale, without, doing whatever, then maybe we can accomplish what we're trying to accomplish.
Right.
Right.
Yeah. And I think that even under Mahmoud, even under this decision, there is a way to incorporate these books into the classroom without running afoul of this decision.
I think so as well. Yes.
And I think Jamie, to your point, getting these ambiguous standards that basically, we're in uncharted territory because we don't have past practice to go off of. We don't have all the other cases that have dealt with the coercion exposure standard. So now we've got Mahmoud with its substantial interference standard. And so we don't have guideposts. And when there's no guideposts, there's just a lot of gray. Yeah. And the safest thing when there's a lot of gray in the law is to not get into the gray areas.
Yeah.
And we've got to ask the question okay, well, if we want to avoid the gray areas, what are we sacrificing in doing that? What kind of educational benefits or educational goals are we going to have to sacrifice to do that? And, I think that there's a lot of nuanced ways to approach this opinion and approach the new kind of right to opt out that it recognizes that could, both respect the religious liberties of these parents while also making sure that schools can still pursue these very laudable goals about representation and inclusion in ways that affirm the educational value, don't undermine those rights, and help students explore these ideas in productive ways. So, all that to say is don't overreact.
Yeah, exactly.
Don't underreact.
Don't
overreact.
Yes, but you should react.
It's probably going to need a reaction. Yes. Yeah. Don't do nothing.
There it is again.
Yeah. So to kind of think through that substantial interference here, the court gave us a bunch of things to think about, and I already kind of alluded to the two big things for Alito in the majority opinion that kind of tip the scale here towards that substantial interference is the books themselves. He says the books themselves are unmistakably normative, meaning that they are clearly designed to present certain values and beliefs as things to be celebrated and certain contrary values and beliefs as things to be rejected. Yeah. And Jamie, you and I already kind of joked about how much of this opinion is dedicated to interpreting these books. At this point, there are 4 entire pages parsing the messages of these books. So we joked at the oral argument that Justice Sotomayor and Justice Alito were having a debate about the literary interpretation of Uncle Bobby's Wedding, right? And it's in the opinion too, which I think is really kind of problematic that we don't want courts to be engaged in literary interpretation. I just don't see how that's their expertise, how that's their job.
No,
we shouldn't be asking courts to hey, what are the social or what are the messages or themes of this work, right? Go read Crime and Punishment and tell me what the themes are and how those undermine or potentially conflict with my religious beliefs. It just, maybe it's easier because these are kids' picture books, but I don't know. I feel
it feels
uncomfortable
they're
with
not staying in their lane. Yeah,
exactly. Right.
Yeah.
That's my lane. I'm a former English teacher.
Yeah, it ain't my lane.
So the other thing that the court is concerned about, in addition to the content of the books, is the way they were presented to children by the teachers. Jamie, we already kind of talked about this a lot, the teaching guide. It told teachers how to respond to questions and families. And according to Alito and how he interpreted the teaching guide, it basically instructed these teachers to explicitly contradict their parents' religious views and encouraged teachers to correct the children and accuse them of being hurtful and that, that they weren't being respectful if they expressed their ideas based on their religious beliefs. And that is kind of the biggest, I think, That's the big issue here.
Yeah. And to reinforce the point that I'm making, that I made before, like whether or not that happened in reality, because again, this is just what Alito is pulling out, right? Like whether or not that happened is not necessarily the question, but what it should do is it should force us all to think about how do we proactively make these curricula neutral, right? Like how do we avoid the perception of this happening? Right.
But like that raises the question, like, how can we make a neutral curriculum? Right. Like,
exactly.
Because all of the curriculum is going to be value laden in some way.
100%.
And so that's just such a hard thing to do.
But it's not impossible, right?
No.
It's, I think that's all that I'm saying is that I think we can still get the messages and the values, like it's all value laden, as it should be. But how can we do it in a way that respects everybody's, uniqueness, their history, their individuality? That is a very, very hard thing to do.
Right. And that leaves room for alternative beliefs and views, right?
Exactly.
Yeah. No, I agree.
Yeah.
It's a necessary work. It's going to be really tough because, education is inherently value laden.
Right. Exactly.
And the reason all of this matters so much is what the court does next is that line of substantial interference is pretty much the only stopgap we have in the court's analysis, meaning that like as soon as you get past that line of substantial interference, like you're pretty likely to be violating the free exercise clause because the court says that once you get past that substantial interference requirement, strict scrutiny applies. And that's interesting because typically what happens is if you've got a law that incidentally burdens religion, we ask two questions. Is that law neutral towards religion? Like it doesn't favor or disfavor religion. It doesn't target religion for unfavorable treatment. And is that law generally applicable? Meaning like, are there exceptions to it for other things and not for religious things? If so, that's a problem. And so if the law is neutral and generally applicable, then, typically those laws are going to be fine. But if they're not neutral and generally applicable, that's when we trigger strict scrutiny, which is, the most kind of intense judicial review where most laws will fail strict scrutiny because they infringe on fundamental rights and there's not a substantial justification for them.
Yeah.
And that was a big conversation with Richard Katskee when we had him on to talk about the oral argument. We talked about like, how are the justices going to get to strict scrutiny? Because we all knew or kind of anticipated that they'd get there, but we didn't know how. And there was a lot of disagreement because some of the justices were going to say like, oh, this was really just discrimination. And some of the justices were going to say like, oh, this isn't generally applicable because you give opt-outs for lots of other things. And the court doesn't touch any of that. And they just say like, well, if it's like Yoder, if it's of the same character as Yoder, where there's a substantial interference with the right to direct the religious upbringing of children, that goes straight to strict scrutiny, doesn't have to pass go, gets to collect $200.
Right.
In this case, gets to collect an injunction. And so, they apply strict scrutiny and most laws that strict scrutiny gets applied to don't fare very well. So you have to be narrowly tailored to accomplish a compelling governmental interest. The court does acknowledge that there's a compelling interest in having an undisrupted school session conducive to student learning. So that's good. Yeah, right? Like it could also be bad because now you've got an undisrupted school session conducive to student learning. Like maybe we use that to justify other curtailments of students' rights, but hopefully I'm just reading too much into that.
Yeah.
But the court says that like, even though with that compelling interest, there's no narrowly tailored.
Yeah.
You don't meet the narrowly tailored requirement because these opt-out policies don't accomplish that interest or they're not necessary to accomplish that interest. You can accomplish that interest without these policies and you allow opt-outs in lots of other situations, all of that stuff to say like, you don't fail narrow tailoring, which is why I think it's so important to get that substantial interference line right, because once you get past that line, it's pretty much a slam dunk for the parents.
Yeah. Yeah.
There might be situations where it could pass narrow tailoring, but I think that those are going to be more extreme cases. But, all that to say is we'll see. We'll see what happens with that.
We'll see.
So, the court also does acknowledge that like there are some limits here because, it does what the court always does, which is kind of say that like we are not in the business of micromanaging schools.
Except
even
when
though
we micromanage schools.
Even though we just did a book report about, the 5 books that you chose. And the court also says that like this decision deals with parental opt-outs. It doesn't deal with parental efforts to micromanage the curriculum.
Yeah.
And to me,
it's Alito's point from the oral arguments. Like, what's
Right.
the big deal? It's just an opt-out. We're not asking you to change the curriculum.
Right. And to me, that rings a little hollow because what's the consequence of the threat of opt-out?
It's a
Change your
watering down
curriculum.
of the curriculum.
Exactly. Right. Like,
Yeah.
So, you know, that and the practical concerns, Jamie, that you rose, like, don't get a lot of play here.
No.
And Alito actually even says in the opinion, he says, like, the fact that you anticipate a lot of opt-outs indicates a greater problem. Not a problem for you, a greater constitutional problem, because he basically says there's no, and he uses this exact language, there's no de maximis standard, where basically, like, if you violate everyone's rights, it's okay. And that feels really flippant, but that's neither here nor there, I guess.
No, I mean, I get what he's saying. I don't agree with it. You know, like he's kind of saying, you know, if you think there's going to be a lot of opt-outs, then what does that say about your curriculum? That it's already very problematic. And no, I mean, like, again, we're not taking into account the burden that opt-outs can have on schools. You've got to pull kids out. You've got to often provide them with alternative lessons or programming or whatever so that they can still meet those standards, right? You've got to provide supervision.
But I don't think the decision goes that far. So the decision just says, like, you have to provide. So the court finds that there's substantial interference. It says that, you know, this policy or the no opt-out policy isn't justified by strict scrutiny. Therefore, because we're in a preliminary injunction stage, the parents are likely to succeed on their claims.
Yes.
So all it says is, lower court, you need to issue an injunction that allows for notice of when these books or similar books are going to be used and the ability to opt kids out of them. It says nothing about administratively what to do about that opt-out.
Right. But we also know that, you know, there are required standards in state curricula, you know, and so states are just going to have to, you know, they're going to have to take that into account, even if the court didn't talk about it here.
Right.
It's still a reality, you know.
It is a reality, but I think that, like, it's going to be a really interesting test case when something like that comes up where they want to opt out of, like, a required part of the curriculum. And, like, you know, the biggest one that comes to mind is evolution, right? If the science standards include evolution, is that going to run afoul of Mahmoud? I would say no, because
they gave that age thing. And
not just that, but, like, to me, like, here's the Chris Thomas distillation of the rule in Mahmoud. Are you ready?
Yeah.
This is what I think the rule is. To justify an opt-out, the curriculum, or sorry, not to justify an opt-out. That's not the right way to phrase it. But, like,
not off to a good start, man. With the Chris Thomas
this is a work in progress. I'm a work in progress, Jamie. So schools are required, how about that, to provide an opt-out when the curriculum makes a value judgment. So that goes back to Alito's thing about normative, right? Like the curriculum makes a value judgment about what is right or wrong, you know, good or bad. And I think there's two pieces to this. So the curriculum makes a value judgment. And the second piece of it is students have to be pressured in some way to accept that value judgment in opposition to the values or beliefs of their family.
Okay, so there's
particularly their religious beliefs.
So there's two things there. So I appreciate your take on this. I don't think that the first piece of it is all that impactful because of what we talked about before, about how all curriculum is value laden and there are value judgments there. I think the second piece is the critical piece, right?
Well, I think that some curriculum is going to do it more explicitly than others.
Of course.
Right?
Of
like
course.
If you've got a book that says, like, evolution is truth and you're dumb if you don't believe it.
Right?
Like
100%.
That, obviously
100%.
That's more normative.
Yeah.
Right?
Yeah.
But you're right. I think like
the second piece is the
like,
heavy piece.
But that's also the piece that gets emphasized in the opinion. Like, to Alito, he spends so much more time talking about the content of these books than he does about how they're actually taught.
I know.
I think you need both pieces. I think you need curriculum that makes a value judgment and some sort of pressure, some sort of like context or like, you know, exposure plus context that exerts pressure in some way.
I completely agree. I'm not saying we should throw out the first point, right? Like it's a part. I just think that the second point is the real thing there, because I don't want us to get hung up on the first one and, you know, and throw out things that might have value to it, right? without focusing on whether or not the second point is
Right. It's all about like
met.
how you present it. Right.
100%.
Yeah. Yeah.
And I think, but the other thing that really concerns me about all this is they kind of said in the opinion that, like schools really need to provide notice. And
How do you know?
how do you know what's going to upset somebody or burden their religious beliefs? There's a lot of beliefs out there.
Right. Yeah. I don't know everyone's religious beliefs. And I also don't know like how they interpret or understand their beliefs. And I also don't know how they're going to interpret or understand my curriculum.
Right.
So like there's so many unknowns there. And yeah, that's a great question. Like, how do you know when to provide notice? I think we're going to see a lot of very proactive things. And maybe it's good for like transparency and community engagement where schools are being much more transparent or forthcoming about their curriculum.
Mm-hmm.
But like, I don't know if I have an answer for that. And I don't think Alito does either. Like,
I don't.
he's
That one's
very specific on these 5 books.
Yeah, I don't. This is the piece that really makes me nervous about the kind of burden this could end up having on schools, because I would just say it's probably close to impossible to anticipate.
Which is why I don't think it's going to be an anticipation thing. I think it's going to be a provide transparency.
Yeah.
And when you get a request,
Engage.
ask yourself, engage with them and ask yourself, on the legal side, is the curriculum
Is it pushing?
Or is it pushing something? Is it presented in a non-neutral way, whatever it might be?
Yeah.
And, is it taking sides on right or wrong? Or are you just describing how the world is or how specific domains or disciplines understand the world?
Yes.
And if that's the answer, then you probably don't need to provide an opt-out. But, the practical answer is is it worth it? And what is that going to practically look like if you do provide the opt-out? Because I don't think based on this, that's going to be the next case. The next case is going to be okay, do you have to provide an alternative? Based on this, I don't think you have to provide an alternative. I don't know exactly when you do and when you don't, though. But I don't think that this decision requires every teacher to provide a brand new lesson plan to every single student who opts out. I don't think it goes that far.
Okay. Well, no, I don't think it goes that far. I think that that's something that's going to be determined at the state and district level, right? And along with whether or not somebody, a school has to provide supervision as well. Could a school turn around and say, you know what, fine, you can opt out of this particular unit, but we don't have space for you. We don't have supervision for you. We don't have alternative lessons for you. So you can come pick your kid up.
Yeah, that might go too far.
I think that would go too far.
Right. Because now we've got a right to education or due process entitlement to education issues.
So all I'm saying
also
is that
got negligence issues about supervision. You got to provide reasonable supervision.
Right. Yeah. But that's my point, right? How far is this going to go?
Sure.
And, how much of a burden is it? So even if you don't have to provide an alternative lesson, you're going to have to do something. Mm-hmm. You're going to have to do something more than what you were doing before.
Sure.
So how much more often, for how much more, how many more additional kids?
Right. All of this is going to depend on how aggressive schools and parents are in fighting over where these lines are.
And I think what you're going to very quickly and easily see is some communities are going to handle this incredibly differently.
Right. Yeah. Because some communities already have universal opt-out policies. And we'll see if that's kind of the direction that everyone goes, where basically it's a, don't ask, don't tell. Hey, if you want an opt-out, it's yours. Take it.
Yeah.
And that was kind of, when this decision came out, we posted a meme on our Facebook page of Oprah with her arms out saying, you get an opt-out, you get an opt-out, everybody gets an opt-out, right? That's probably going to be the implication here, even though I don't think that that's necessarily, if you want to take a really kind of nuanced look at the decision, where the legal line is.
Yeah. Yeah, no, it's, and again, I think this is going to be the way this plays out is going to be very community specific, and it's going to be interesting to see how curriculum evolves in particular
in light of this, right?
Communities, right?
Yeah. And that's something that from the law side that I have a lot of questions about, this is about parental rights to opt out. It doesn't affect school authority to adopt the curriculum, but
nope.
There's not a lot of daylight here between when you're allowed to opt out or when you have to when you're required to provide an opt out and when the school exceeds its authority to adopt the curriculum, because, Barnett and Pico kind of said that schools can't adopt authority for purely ideological reasons or to promote orthodoxy or, particular viewpoints. And now we've got this one saying that it's a substantial interference when you present curriculum that interferes with religion in a non-neutral way. And there's daylight there, right? But it's this question of okay, well, if this is an opt-out case, what does that tell us about schools' authority to adopt curriculum? Mm-hmm. And, even if we don't go there and don't revisit those principles, then we still have the pressure of providing opt-outs that's going to shape curricular decisions.
Yeah, exactly.
There's a lot to unpack here.
We have had our hands full this year with...
We have. It's nice that the Supreme Court term is over.
Yeah, thank God.
Though there's actually still a couple more cases we got to talk about.
Yeah, no, totally.
That'll be bell ringers, right?
Yeah, exactly.
Gosh.
But, I'm ready for a little break, but I don't think we're going to get one. There's a lot going on in education law these days, folks.
Right. And the Supreme Court already took up a case about transgender athletes.
Yes, exactly. So we've got that one coming next year.
We've got another one coming.
Yep. And that's a big one. So,
But, bottom line with Mahmoud, it's an important decision. It recognizes a new kind of parental right to opt out that, maybe didn't exist before, or if it did, it had different standards than it does now. We know that
it at least hadn't been addressed legally before.
By the Supreme Court, right? We've had that kind of coercion exposure line from the lower courts, but now, that's
now
not
you've got the religious piece. Yeah.
We've got this line that's more aligned with non-neutrality or normative plus prescriptive, right?
Yeah.
If you're being descriptive, you're probably fine. If you're just describing how the world is or how different disciplines view the world, you're probably okay.
Yeah.
If you're being prescriptive, now, if you're telling people what to believe or what is right or wrong, that's a problem. And so,
yeah, it adds a little nuance.
It adds a little. Yeah. It's another layer that we've got to think about that we didn't have to think about before in the same way.
Right.
But ultimately, we'll see what the implication is. Jamie, I think you're exactly right. It's going to depend on how communities deal with this. And it really just emphasizes the importance of relationships as something we've talked about so much on this show.
Right. Yeah. Well, there you have it, folks. Mahmoud versus Taylor. It's a wrap after 3 episodes and probably 3 bell ringers and everything.
You got a lot of content after this.
I know, exactly. I'm sure we will come back to it as we see potential cases, sort of pop up that will rely on the Mahmoud decision in one way or another. So, we'll keep you posted. And so what is our homework? I didn't thought about that, did we?
No, I've been so busy trying to understand this case. What's a good homework?
I can tell you my homework is I'm going to get out of here and go canoeing probably with some kids.
Oh, that sounds awesome.
That's what my homework is. It's summer, man. That's what we should be doing. What?
I might go do a bike ride. That sounds good. Yeah, your homework is to go
get out
enjoy.
There. Yeah.
Hopefully nice weather wherever you are.
Yeah.
And keep your earbuds in and keep listening to Chalk and Gavel wherever you get your podcasts, obviously.
Yeah, exactly.
You see that connection? That was good.
Well done.
Thank you. Thank you very much. Rate, review, Chalk and Gavel. Your support means the world does. Tell a friend, tell a colleague. A shout out from the rooftops. Go to our Patreon, patreon.com/chalkandgavel. $2 a month goes so far in helping us build and grow this show. Jamie and I have so much fun doing this. And, I've said it before, I'll say it again. As long as you all find value in it, we will keep on doing it.
All right. That sounds good. All right. We'll see you in a couple of weeks for episode 49. Folks, have a good one.